bring your video on.
Have you got the other two judges? We've got Lord Justice Underhill.
I think you can see me and hear me. I'm really sorry. I do apologise. Something to do with the link.
Don't worry, Mr. Mansfield. I just want to make sure I've got the other two members of the bench present.
Yes, I'm here.
You have me as well.
Very good. Thank you very much. Right, Mr. Mansfield.
It's Henrietta, my learned friend, is going to address you first and then me.
Thank you. Yes, Miss Hill.
My Lord, I was hoping in reply to raise, I think, 4 short points, if I may. But my Lord, I don't know if you did want to give any indication on the EU law point before I start.
I'm so sorry, you're quite right. Yes, we will not require any further submissions in relation to the EU point.
I'm grateful, my Lord. My reply then, my Lords, will focus on, I think, 4 short points that respond obviously to the age and sex discrimination arguments that were made before you. First of all, my Lords, my Lady, please could I take you to the Carson Authority at tab 27 of your authorities bundle. It's the House of Lords in Carson. There's one short passage I'd like to take the court to in that authority, if I may.
Which bundle is it?
It's tab 27, which I believe is in bundle 2.
Thank you. Yes, thank you.
My Lords, within...
Sorry, Miss Hill, I haven't got it yet.
Oh, forgive me. I'm sorry, my Lord, I can't see... I can see you now on the screen, thank you.
And that was me just burrowing around trying to get the bundle. Which tab? 27?
So, tab 27. It's the passage that begins, please, at paragraph 55. Just a couple of short points, if I may, that to be elicited from that passage. This is a passage that turns on the issue of suspect grounds, which has obviously been the subject of some submission. And the passage at paragraph 55 in Lord Walker's judgment traces the history of the suspect grounds doctrine through American law, looking at the fact that particular suspect categories are so defined partly because they are personal characteristics that an individual cannot change. And my Lords and my Lady will see reference in paragraph 55 there to sex, race and sexual orientation. And over the page, through paragraph 57 and onwards, the similar doctrine is traced through the Strasbourg jurisprudence and then into domestic law. And there are references made throughout 57 and 58, my Lords and my Lady, to the issue of sex being one of these grounds where very weighty reasons are required, and tracing the Strasbourg authorities quite some way back. And finally, just on this passage, please, over the page at paragraph 60, there is discussion about the way in which age fits into this analysis. And Lord Walker's observation of paragraph 60 is that age is a rather different type of personal characteristic and is different to the ones that have gone before. But there is no dispute, I believe, between my learned friends and myself around whether age in principle fits within Article 14. But my Lords and my Lady, the short point I'd make from that passage is that where there has been discussion and submissions around whether the weighty reasons approach might apply to indirect discrimination. I'm so sorry, I think we may have lost Mr. Mansfield again. I've just seen him drop off my screen. Perhaps I can just carry on and complete this submission.
Well, I think you carry on, and we'll see when we get to him, we'll see where he is.
Thank you, my Lord. The submission I was hoping to make on this passage is broadly this, that there's been consideration about whether the weighty reasons test is applicable only to direct or indirect discrimination. And the submission I've made based on this paragraph is that the illustration here is that the genesis of those suspect ground categories are to do with the nature of the characteristic being fixed or something that a person cannot change, rather than the nature of the discrimination. And so there would, in principle, it seems to us, be nothing to say that that weighty reasons test, which we would submit is well established here in Strasbourg and indeed overseas authorities, couldn't apply to indirect discrimination. or indeed, my lords, my lady, to a case of combined discrimination of which sex is part. And of course that is our case in the alternative.
So I'm being slow. I'm not quite sure what point you're addressing. Are you addressing the point whether suspect grounds, the whole suspect grounds line of authority applies to indirect as well as direct? Or are you approaching saying does it apply to age?
It's the former proposition, my lord. The reason I went to the age passage is because I think when I was making submissions before, I didn't take you to that part. It's just to illustrate that there is recognition of age falling within Article 14. The point I wish to make for submission purposes is that the genesis of this weighty reasons or suspect grounds doctrine is the nature of the characteristic, i.e. sex. And so there's no reason in principle why that wouldn't apply to indirect discrimination. And I was just, I think, making the further submission that there's no reason in principle why that wouldn't apply to combined discrimination of which sex is part.
But I thought it was common ground that the manifestly without reasonable foundation test was appropriate for the age discrimination case that you're putting forward.
It is, my lady, and forgive me if reference to age has confused that submission. For the age discrimination argument, it is accepted that the manifestly without reasonable foundation test is the appropriate one. What I think has been more controversial and dealt with in submissions is whether, even if we are right that on the sex ground it's the different test, the weighty reasons etc. test, that there is a doubt over whether that applies because the nature of our sex claim is of indirect, not direct discrimination. Does that answer my lady's question?
Right, but the weighty reasons test is a different test from the manifestly without reasonable foundation test, isn't it?
It's obviously been the subject of consideration in the JCWI case, and I'm not dealing with the age discrimination ground here. I'm simply dealing with the sex discrimination ground. That passage.
So what your submission is that if you're right that it should be weighty reasons rather than manifestly without reasonable foundation for your sex discrimination claim, that is the case whether it's a direct or an indirect sex discrimination claim. Is that what you're saying?
Exactly, my lady.
Well, now,
also,
sorry, can I just intervene at this point? Certainly, the respondent has accepted the analysis in the JCWI case. My understanding is that the manifestly without reasonable foundation test may not be wholly inappropriate, even in a case involving sex discrimination. But if you have one of these personal characteristics which don't change, as you said, I thought the analysis in the Lord Justice Higginbotham's analysis is that you take it into account. In other words, that the overall test is manifest without reasonable foundation, but that is that's a fluid test. It's not a kind of a binary test of any sort, and that you have to take into account, on the one hand, the importance of, as you've illustrated here through the cases and so on, you take into account the importance of suppressing or avoiding, whatever the word you like to call it, eliminating sex discrimination like the other characteristics you've mentioned. But it's taken into account in the context, for example, of institutional accountability and responsibility. And the analogy that I'm thinking about, for example, would be in a case where you have in an institutional setting important considerations of one sort, but there also arise important issues, for example, relating to a person's right to a home or some other consideration like that. In other words, there isn't a clear division necessarily in all circumstances between the two tests, the manifestly without reasonable foundation test is capable of accommodating the importance of trying to eliminate sex discrimination. That's where, at the moment, it seems to me, the position lies. But do you disagree with that?
No, we don't, my lord. The submissions that I made around paragraph 136 reflect exactly what my lord has said. We don't disagree with that at all. I think the shorthand I was trying to convey, and forgive me if I cause any confusion to the court, is that it's never been our proposition that JD affects the age ground.
Yes.
And so forgive me if I'd short-circuited that in the shorthand. If my lord's analysis of paragraph 136 of the JCWI case is right, then there is scope for incorporating consideration in the way that my lord has given of the nature of the discrimination in the manifesto without reasonable foundation test. The submission I was simply making here is that where in paragraph 136 of the JCWI case reference is made to gender, in our submission, the route to the inclusion of gender there is because it fits within this suspect category because of the nature of the discrimination, of the characteristic, and that could apply to either direct or indirect discrimination.
Yes, well, that makes...
So sorry.
Well, I have to say that, I mean, I can't speak for anybody else, I only speak to myself. At the moment, that seems to be right. So if we assume for the moment that we're looking not at JD, but at the English precedent on that, or the UK precedent, then, and so it is, the test is manifest without reasonable foundation. That doesn't mean to say you jettison paying particular regard to the importance of preventing, eliminating discrimination based on sex and various other things as well. You have to feed that in. And you would say, if you're going to deal with justification, the decision maker has to show they've taken that into account.
Exactly.
And given it due weight. That's the point you're making. You give it due. You still have to acknowledge that it has to be given special and due weight.
My lord, exactly. That is the submission.
Right, thank you.
Could I just come back for a moment to the actual point you were making, which was that the special weight to be given in the case of suspect grounds of discrimination applies as much to indirect discrimination as to direct discrimination. At very first sight, one would think, well, that must be so because you can't justify direct discrimination. So the question never arises. But in fact, of course, that's not the position in Strasbourg, is it? In Strasbourg, you can justify direct discrimination.
Or indeed age domestically.
Or indeed, yes, I know, but sorry, Dave, I thought we just had 5 minutes saying what this point isn't about age, this point is about sex.
It is.
Yes, sorry, so can we stay with sex? And I'm right in thinking, aren't I, that in the Strasbourg jurisprudence you can justify sex, just direct sex discrimination. It's obviously more difficult, but you can do it.
Yes.
That being so, if you look through this passage, which I must have read in the past, but haven't read for the purpose of this hearing, obviously there's a lot of law referred to here, but the underlying reasoning does seem to be based very much on direct discrimination, not indirect. And it's based on the fact that it is inherently demeaning to be treated less favourably on the grounds of one of these immutable characteristics. Where you are simply the victim of something which isn't targeted at you at all, but has an indirect effect, let's say a qualifications requirement which statistically may be more difficult for one gender than another to pass or whatever it might be. I don't really see anything in these page and a half which really would easily apply to that situation. And such little bits of language as one finds look as if it's intended as direct discrimination. Para 56 talks about purpose at the very bottom of the page. The US Supreme Court in Rodriguez talks about purposeful unequal treatment. So that's obviously American for deliberate. And quote from Gairan in the middle of page 192 talks about differential treatment based on grounds such as so and so and so forth. So I'm just raising with you, in case any more you want to add on this, it doesn't seem to be self-evident that this particular rule is applicable to the case of indirect discrimination. It appears from the cases that Lord Walker summarises.
My Lord, I think it's fair to acknowledge the development of the principle in the way that my Lord has done. The passages don't descend into any detail as to the type of discrimination in issue. I think it's right to recognise that none of our written submissions have gone into any particular detail on this point in question. I think the submissions between us have gone rather beyond that. The passage at 58 that talks about the Strasbourg jurisprudence simply refers to justifying discrimination, but doesn't descend into any further detail.
Well, yes, but if anything, it reinforces it. It's talking about discrimination on these grounds. Grounds tends to be the language of the reason why you are doing something. That's the language of direct discrimination. I know people use language loosely here. I'm not myself convinced that this is a point of fundamental importance. I think that's really indicated by what you have just said. But you've chosen this one of your 4 reply points, so I thought I should just say that at the moment I don't think this passage shows what you say it shows.
Well, my Lord, the only other point I'd just make to perhaps address that is that, just for your note, in dealing with the definition of indirect discrimination in JD that I took the court to, the use of protected ground is mentioned there as well. So that's just perhaps a note on that. But I can move on from that point. My Lord is quite right, it's not a crucial point. My Lord, the second point briefly I wish to make to my Lords and my Lady relates to a paragraph in our skeleton, please, to paragraph, or forgive me, in the judgment below, paragraph 28 of the judgment below, dealt with the series of legislative changes. And could I just flag, please, that paragraph 28 of the judgment below, which is at page 75 of the core bundle, made clear that the changes implemented in the 2011 Act, just perhaps wait for the court to get that passage, it's page 75, paragraph 28.
Yes.
It's just to flag, to perhaps remind the court that the 2011 changes at paragraph 28 were applicable to both men and women. And so to the extent there's been questioning around and submissions around the nature of the PCP, if you like, or the condition, it is obviously a series of legislative changes here, but the very final one, the 2011 Act, is a gender-neutral change. And it's the cumulative effect of those changes on which we rely. So it remains our submission that the pool can be drawn in the way that we've said.
Well, that, Ms. Hill, is in a case in a direction which has not been taken until this moment, which is to distinguish in your grounds between your case under the 1995 Act and your case under the 2011 or subsequent cases. Now, it seems to me that the evidence has not been directed to the question whether the difference for this cohort between the age being 65 and 66 is a material difference. And I think I'm just concerned that it's a bit late in the day to start differentiating between the two acts and saying, well, there is a neutral measure in the 2011 Act.
Well, I just wish to highlight the fact that it's part of the factual background that that particular element of the changes was gender neutral. It goes no further than that. The third point I wish to try and address was my lady's questions around I think the phrase was the mismatch. I hope I can try and deal with the mismatch point. I think the concerns that were raised were around whether or not there is a difference between the claimant's or the appellant's case on age and on sex that cannot be reconciled. But in our submission, as far as the age claim is concerned, we do continue to compare the claimant cohort with the older women for the purposes of the age discrimination claim. But in our submission, it is still appropriate and possible to look separately in the sex discrimination claim at the, to use the phrase from JD, the particularly prejudicial impact, and that it is possible to have those two different scenarios without there being an irreconcilable conflict between them.
Sorry, I understood that. I understood what you said for the age claim. What are you saying for the sex claim?
I think that the query that was being raised by my lady, and I hope I've understood the question correctly, that was put to both my learned friend, I think, and myself, is really whether there is a mismatch between the group against whom the cohort compares itself for the less favourable treatment discrimination claim on grounds of age, and the group against which the cohort compares itself for the purposes of particularly disparate impact under the sex claim, and whether the fact that those groups are different is a particular problem for the claim. I hope, my lady, that that's the mismatch that you were alluding to in the questioning.
No, but I don't see there's a difficulty in having a different comparator group for the age discrimination claim from the sex discrimination claim. Of course you would, because of the sex discrimination claim you're presumably comparing yourself with men between the ages of 60 and 65, who also do not get a pension, but who you say the evidence shows don't need the pension as much as women in that age group do. What I thought was the difficulty was in, and this was in within the age discrimination claim, comparing yourself with the older women, but then saying that the disadvantage arises because of either comparing the cohort with men or with younger women, because I don't see that the evidence establishes that women born before 1950 are better off socially or economically than women born after 1950. So, I mean, I think it would be helpful for me if you would just, for the age discrimination claim and the sex discrimination claim, just perhaps go through again who is the comparator group against which the existence of a disadvantage is to be measured in both instances.
Well, yeah, I'll try and assist as best I can. On the age discrimination claim, the initial three groups that my learned friend Mr Mansfield set out that are created by the legislation create the different groups, and our comparator group for those purposes is the older women group. If we are right on the reading of Ackerman and Zammit and Minter, and that we can properly compare our cohort group with that group, then the next question is one of justification. And at the justification stage, it's our submission that there are obviously, as my learned friend has submitted, a large range of factors that go into the pot on justification, if I can put it that way. And our submission would be that the impact, the disproportionate impact on women, and in particular women of a certain age, so effectively at that point a combined discriminatory impact can be taken into account at the justification stage. As far as the indirect claim of sex discrimination is concerned, there isn't the need for the direct comparator group because there is no less favourable treatment being alleged. So the question in JD terms is, again, bearing in mind this is a Strasbourg claim, an Article 14 claim, not a domestic law claim. So the question on the indirect discrimination claim is there a policy or measure that has disproportionately prejudicial effects on a particular group? And the group, for the purposes of the sex discrimination claim, is the women, but in particular, as you know, we argue for combined discrimination. So the question is, has there been disproportionately prejudicial impacts on the women at a certain age within that group? And if so, does it fall to be justified? And again, at the justification analysis, the court would have to be satisfied that the decision maker and the court below has fully considered the particularly prejudicial impact and taken that into account. I hope that assists my lady as best I can on that point. If it pleases the court, then the only further point I'd wish to make is simply to draw out, as you've heard between Malone and Friends and our submissions, obviously there is the principle that we've relied on, my lords and my lady, at paragraph 16 of our Skeleton argument, the DA proposition, that the discriminatory impact has to be considered by the decision maker and the court below. And we have, as you know, relied on the combination of both gender and age. And we provided yesterday, my lords and my lady, the case of A. And I just wish to flag in that, if I may, the way in which that issue was dealt with by the court in A. And I don't know if you have that loose, but it was the authority that I think was handed over in the short adjournment yesterday. It's the 2017 Supreme Court case R.A. v Secretary of State for Health, with Alliance for Choice and others intervening.
Stuff here. Where that is.
I think it came, if it helps you, with the Strasbourg authority, the Marcos, very long authority. It's a much shorter one that came at the same time.
I received it at 13:59. Yes.
I'm grateful, my lord.
That may need to be my front part there, she got it to you, but shortly before I see it.
Yes, I got it.
Does my lady have it?
Yes, I have it.
Very briefly, if I may, just to indicate, in the case of A, if one goes please to paragraph 23, the court can see between paragraphs 23 and 31 consideration of how the...
Sorry, you're going a bit too fast. Which paragraphs were it for?
Forgive me, my lord, paragraph 23 under the heading Other Status.
Got it, yes, thank you.
And the court can see perhaps at the beginning of paragraph 23, it's no criticism of the claimants to record that the ground of the alleged discrimination has been formulated in different ways, for the relevant concepts are difficult, and the court goes on here to consider the ways in which the claimants have framed their other status. And my lords, my lady, can see at paragraph 27 that there is reference back to the Strasbourg authority on combined discrimination. That's the case of BS, which refers there to a woman who was black and a prostitute, relying on combined discrimination. There are other Strasbourg authorities around that, but one can see in this authority, just very briefly, that at paragraph 26, the status that was relied on had changed as far as the appellant's or claimant's case was concerned, and that they relied on the status as defined at the end of paragraph 26. Women who are UK citizens present in England and usually resident in Northern Ireland was the status relied on. And the court went on then to consider the impact on that group. And without wanting to trouble the court too much, we've provided, I think, over the course of this morning, just two further authorities that reflect consideration of combined discrimination in a similar way. And just perhaps for the court's note, if I could ask you in due course to...
Can I just be clear about this? I didn't think there was any issue about any of this. Did Sir James say that combined discrimination wasn't possible? I don't know what point in his submissions you're addressing.
It's simply to reiterate the nature of the test that the court below should have applied and what it should have looked at, which obviously is squarely an issue between us, and simply to reiterate that when we've made submissions around the DA principle that the court below had to look at the nature of the measure in question, knowing of its discriminatory impact, that our case relies on a combined discrimination analysis. It goes no further than that, my lord. So perhaps I don't need to trouble the court with anything further on that particular point, but it's simply to reiterate.
Maybe my lord and my lady, but I was just want to hear more about this, but I was just puzzled what it was going to, but you explain.
Well, my lord, it may be that we haven't addressed it as much as perhaps I should have done, but it is a key part of the case, and therefore a key part of how it is we say the court below erred. And for your note, just the final point on this is that the.
Well, I'm sorry, Miss. I'm lost on this point. I've always understood your case to be, in relation to sex, that it's both sex and age combined. It's always been your case. So I'm just not quite sure what this is going to.
Well, my lord, it's simply to make, or perhaps to reinforce the point that when one is looking at the exercise carried out by the court below, and indeed by the decision maker, that the DA principle, that the decision maker has to be satisfied that there is justification for the measure in question, knowing of its discriminatory impact, that here we emphasise both age and sex and the two combined. And the only reference to the latter, the combined discrimination point, is the short reference to paragraph 75 of the judgment below. And those are all the submissions I wish to make on it, my lord.
Okay, can I just take you up on the second point, which my Lady Justice Rose has referred to? I'm slightly troubled by this. I thought that the overwhelming thrust of the evidence was that it was the change from 60 to 65 which really lay at the heart of the concerns of the claimants. And we've heard argument in relation to that, and the argument of the respondent, rightly or wrongly, is that as regards that, there is no neutral factor. It's direct discrimination, they say, because the men nothing changes as regards them. They've always had a retirement age of 65, and it's only the women who are affected. Now, I'm slightly troubled by how we now have to factor into this the change from 65 to 66, which, as you rightly say, affects both men and women. But I'm not sure that the evidence is directed to that period between 65 and 66. So this produces a kind of a confusion now, or a complexity, because if you're now looking at a different pool with a neutral factor, it should surely be related to that 1 year period, not the whole period from 60 to 66. Otherwise, we're going to get a terrible analytical mess.
My lord, our position on the pool remains what we say at paragraph 47 of our skeleton, page 25, that the appropriate pool to test the discrimination complained of is women it affects and men it would affect, aged between 60 and 66. And so the element that I've drawn out in this reply relates to one part of that, but nevertheless our pool, or the PCP that we rely on, remains that group. And it's simply perhaps to illustrate that in looking at that group, which we submit is the proper pool, there is one element of that which is gender neutral.
All right. Which paragraph? You've got page 25. Which paragraph?
Forgive me, it's in our skeleton. It's
Yes.
paragraph 47.
That's fine, thank you.
Where we apply the ESSOP approach, which is that the PCP in question need not put every member of the group at disadvantage.
Ms Hill, when Ms Rose, Lady Justice Rose first raised this point with you, I noted you as saying that you were only saying that was part of the factual background, it goes no further than that. You've said just now it's only illustrative. That remains your position.
Yes, our submissions on the pool remain as they were, and I was trying to draw out the fact that there is just one element of that chronological history that feeds into that pool that is not gender specific. If I could just have a moment, my lords, if you may. I think that there may just be some messages for me. Just bear with me a second, please, if I could ask the court just to check. My lords, those are the submissions I wish to make in reply on those grounds, unless there's anything in particular I can assist the court with. I think my learned friend Mr Mansfield had some further points to make in reply.
Miss, we're extremely grateful to you. Thank you very much.
Thank you very much, my lords, my lady.
Yes, Mr Mansfield.
Can I just do a test run? Is that
Or we can
being received?
yes, we can both hear you and see you. Yes, we can hear you and see you.
Yes, thank you very much. It does occasionally drop out, but I've managed to get it back, and I hope it doesn't happen now. May I take the points that I want to deal with in reverse order? In other words, I want, with your permission, to deal with ground 4 first, and then work back into notice on ground 3. Really addressing the points, obviously, that have been raised today. But there is a further matter which is a sort of a first document that you may wish to see. You asked yesterday about what happened on the leave hearing, at which I was present, at which I argued this point about, if I can call it timeliness, perhaps, as it embraces both the statutes dealing with it. The promptness point was argued. We now have procured, and it should be behind in your core bundle, tab 14. May I just pause to see if that's been added? We actually got the judgment.
Yeah, I think I've got mine loose.
Added, Mr Mansfield, because if you only got it just now.
Well, I certainly received mine this morning, and I have it loose.
Are you talking about the transcript of Mr Justice Lang's judgment?
Yes.
Yes, oh, sorry, yes, I've also had it, I've got it loose.
It would appear my recollection was right about this. It's paragraph 3 in this judgment. It's a very short judgment, but in this, and it's attached obviously to the order in the same tab. If you're kind enough to look at paragraph 3, halfway through, it says, however, I consider that the claimant have established arguable grounds that the implementation of these changes in breach of their legitimate expectations, and that it has resulted and continues to result in age and gender discrimination and breach and so forth, cites the statutes. If proved, these are continuing unlawful acts. The claimants are not time barred from challenging them in the court. Now, it is necessary because I appreciate you've been asked to consider Lichfield, and so could it's the same paragraph that your lordships may, I don't know if that authority has percolated through to the rooms where you are.
I don't think I've received Lichfield.
We haven't sent it. I thought my learned friend Sir James was going to send it through. It may not have happened, but I can deal with it in summary form. So that,
Reference. Do you have the neutral citation so we can find it on page?
let me just see. I think I do at the top here. I haven't got it in hard copy. It is, the citation number is, I'll read it out slowly, 2001
Goodness.
EWCA Civil, so 304.
Thank you.
Its date is March 2001. And the relevant, well, there are a series of paragraphs that deal with this issue of timeliness, because I appreciate the distinction between the promptness in the rules and obviously the undue delay point which arises under other statutes. Promptness can start at paragraph 28, and the relevant one for purposes of your lordship and ladyship in this hearing is paragraph 34. And in 34, there are a number of preconditions set out, which obviously can do relate to any proceedings of this kind, and they're halfway through that paragraph. If I just go through them, I can do it quickly and read out, and then you can see when you look at the authority where they are placed. Halfway through a long paragraph, 34, the words go by in this way. And first of all, a point I can see that the respondent should be permitted to recanvass by way of undue delay the issue of timeliness as an issue of promptness, which has been decided at the leave stage in the applicant's favour only. And these are the preconditions. 1. If the judge hearing the initial application has expressly so indicated, which is clear from the one I've just given you. 2. If new and relevant material is introduced on the substantive hearing, well, in my submission, the authority, Badmouth is new material in that sense, it's a new case on this. 3. If exceptionally the issues as they have developed at the full hearing put a different aspect on the question of promptness, and we say the material foundation, if you like, for this, the factual matrix has stayed the same. The only difference of aspect is, of course, how Badmouth interprets standing, which I'll come to in a moment. And then finally, the 4th precondition, if the first judge has plainly overlooked some relevant matter or otherwise reached a decision per incuriam. I don't read the rest of the paragraph. Well, my lords, we can see that it can be recanvassed, but effectively nothing was overlooked except the new authority, which obviously she could not have known about at that point. It was argued, and the main authority I remember citing is the one that we put before your lordships, O'Connor. There were others, but that was the main one. So I don't take more time on that, other than to say, well, having, as it were, accommodated Lichfield, the question then is, in relation to Badmouth, the key question that your lordships have and ladyship have already addressed, and that is when two related issues. When does someone get standing, and when do they, to use Sir James's phraseology, when do they have the weaponry? When do they have the means, in the terms of points that they can make, to go to the Divisional Court? And this is an important issue, because in this particular case, it's a very unusual situation. And that is where a statute sets up a regime that isn't going to come into effect for 15, 20 years. That is, on the various facts, a very unusual situation. And we say, if in fact somebody went to court on the basis that it applied to them, we say, at the stage that Act was passed, it related to them, but did not apply to them. And this is, we make that distinction for good reason, because the distinction that you made in Badmouth between person-specific and abstract becomes of relevance, because we say this case is person-specific. It couldn't be more person-specific because of the tabulated differences that you have behind the judgment. Well, that's where you can find them. So we say person-specific, they could not have gone at that stage, and there's very good reasons why the court at that stage would not entertain it, because our submission is this, that if they appeared the day after the statute had come and achieved royal assent and said, we are aggrieved by this, I think the court would be entitled to say, well, we understand your point, but it's 15 years away, anything can happen between now and then. And we don't want a plethora of people, well, thousands actually, turning up at the doors of this court to argue something which hasn't happened yet. And therefore, we say logically, the court would say, well, when you are affected, come back. Now, translating that into the IRC, when you get to the IRC, then maybe you can do something about it, whether you work or whether you don't. And in this case, we say that actually the point of application is the day on which they don't get their pension. In other words...
But Mr. Manson, the court wouldn't really have said that in 1995, would it? Because you would have said straight away, as you've said to us, no, it's too late then. You know, if this is really lawful, it'll have a big impact on us, and we'll have to make changes to how we plan our futures. So we need to know now, not only when it's too late.
Yes, your Lordship's point is entirely valid, but the difficulty here is that obviously there is an additional dimension which is notification and notice, because obviously in this particular case, the notice and notification run together, and in both cases they only learnt shortly before the actual birth date. And of course that places an even greater emphasis on the need for notice to ensure people are aware of what is coming down the line, because they may not wish to challenge it. On the other hand, they may. But not every woman has challenged it. So that's why the judicial review is person-specific. So you have to wait to see whether that individual, when it gets to the crunch date of the birth date and no notice and nothing coming through, that they wish to challenge at that point. They would both have standing and they would have meaning. And this would prevent the courts having a floodgate opened of people applying 15 years too early. Now, it may be that your Lordship's looking at this afresh, may wish to make another date, not that one, in other words, birth date, but it's very difficult, practically speaking, to consider, for the purposes of standing, a date that's earlier. It is a bit like the IRC instance, because, you know, the prisoner hasn't got there yet. And although he might get there one day because he's an immigrant or whatever he happens to be, it's not something that would make much sense. So in our submission, one has to come back to the distinction that is made. It's person-specific, and it has to happen at that particular point. So if the court, on the birthday, where the pension doesn't come through, or the day after, there is a hearing, and the court said for the purposes of undue delay, then we are going to grant you standing to bring the action. Now, of course, it's late in the day by then because they're not getting the pension. However, that's a different issue, because then the court would have to consider what your Lordships are considering is whether the rest of the various statutes are unlawful, and of course the way forward in the end may be political, but it may not be legal. But if the court says it's unlawful, then it's back to the government of the day to consider what they're going to do. But it doesn't, we say, it's not a knockout blow. That's what I'm trying to address. This would not have been, as it is suggested, knocked out either at the leave stage or now for undue delay, because in one case, as your Lordship observed yesterday, is in time, the other one's out of time by about 18 months. So I think probably I've exhausted the observations that could be made on this, other than to say that's as much help as we can render on the wording of badness, which uses the application. It says it repeatedly in the various paragraphs which you've got before you, and I can refer back to them, but I'm sure you're familiar. So, unless your Lordships have any other points on ground 4, may I press us back into ground 3?
Thank you.
So ground 3 The paragraphs in Badness, by the way, that you might want to look at in terms of using the word application are 77, 78 and 85. Now, so far as Sir James's submissions on this are concerned, there are observations which he's making in general form. And the comparison, I think, my ladyship actually dealt with it in a way. His comparison in terms of notice that you know, he compared it with the criminal law is totally irrelevant, because we're not dealing with a whole cohort of criminals who are dealing with their rights. We're not. That's an entirely different situation. Ignorance of the law and so on, of course, would not apply in that sort of sense at all. It's a different, as it were, grouping of people altogether. But it is interesting that that's the example that's drawn on, which we say obviously is not relevant, because we say fundamentally in the approach of the government department and of Wendy Fox herself has made it very clear, and we say this is where the government is coming from. They make it, which we say is so important for the common law at this stage to step in. You have Wendy Fox's statement. I don't ask you to look it up. It's divided to, and it's in the supplementary bundle. And what she says repeatedly in her statement, that she starts at near the beginning. I should start by saying, it's paragraph 4, this one, that it is the DWP's view that of central government that there is no legal requirement for the government to notify people either individually or generally. And this is, we say, an interesting starting point, because it's exactly the position that was adopted below by Sir James, namely the government of the day really doesn't have to tell anybody. Well, I know there's a democratic process, and in general terms, of course, one understands that no government, whether it's either to do with consultation or notification, can be expected to, as it were, find themselves in a situation in which, and I think it was said by Sir James today, it has to apply to all cases. Well, we say that is why we drafted specifically the proposition that we did. Because we don't say that in every single case, but every case within this parameter, yes, but not every single piece of legislation, primary or secondary. It's tailored to deal with well-established, we put in there, serious and well-established individual rights. Well, in this case, nobody's disputing it is a well-established scheme of pensions at 60. But it's the last one, whereby causes serious adverse effects. And I don't think, again, either below or now, there's been any suggestion that there aren't serious adverse effects upon the basic welfare of an identifiable group. So it's not everybody, it's the group to whom it relates. And we say, therefore, if there is going to be, even in future, it's important, legislation which is setting up a scheme that isn't going to come into effect now, but is going to, when it is applied to a specific group, but it is in the area, as I already indicated yesterday, of confusing matters and complexity, which is the department's own wording, then we say this is what is demanded, is some kind of individualized notification on top of all the debate and all the rest of it. So we say we do satisfy the conditions that Lord Justice Sedley was setting out in relation to consultation. We don't say they all apply to notice, but obviously we appreciate that there would have to be here. And of course there was a gap within which it could have happened. Now if the statute overlooks, forgets, doesn't put it in, then the court might want to step in on a common law basis and remind them that there is a duty, a common law duty of fairness. And that's what we would submit. It would have been behoves the department to have approached it in that way, rather than, well, we don't owe it to anybody, is to say fairly, in this sort of case, it would have been an adjunct to all the debate to be able to send out individualised notice. And my learned friend says, oh, well, we didn't have the database. Well, it's very interesting, that particular, we had that argument before, and I don't want to go through the facts of this case. We accept they didn't have a database they wanted to use. However, I think your lordships and ladyship will appreciate that if you fall behind with your tax, somehow or some, they certainly seem to know where you live. And I think they've got addresses for you. So I'm not suggesting anybody here is doing that, but on the other hand, I'm sure everyone is familiar that there are a lot of databases, certainly in the 21st century, which can be used, because it's not just income tax, but council tax, and, well, I needn't go through the whole range. So we didn't accept that that was a satisfactory way of dealing with it. So that on the facts, we say, this could have been done earlier, and more efficiently, and more effectively. Of course, there will be those who've moved address. Of course, there will be those who don't understand the letters. And there will be those, which I can illustrate if necessary, who get letters that tell them the wrong date. So this is another complication of going to the Divisional Court if you've got the wrong date. So, but from the department. So there are all those problems, and one appreciates that. But that doesn't, as Lord Justice Sedley said, because it's difficult, because it's inconvenient, or sometimes perhaps embarrassing, it shouldn't mean that the state doesn't get involved in that process. So may I just pass from those points being generally made about the notification difficulty to something that was said this morning, I know it was a little bit earlier, I think, right at the start of Sir James's submissions to you. What he said was of interest. He was dealing with justification, which I don't want to go back on. It's just to cull from that something he said, which incorporated the need for notice. He was talking about life expectancy. He was talking about public expenditure. He was talking about the difficulties of affordability. Right. Well, that's fine. On the one hand, and I'm not going to go into the facts of that, but set against that, what he was suggesting was there has to be a balance struck. And one of the first things he said, well, how much notice you give? Well, precisely how much notice you give. And we say that's crucial to fairness in this particular incident. So that the notice, we say, well, we've already indicated, it's got to be sufficient. If you are going to, as it were, use a cohort of women, because that's what's happened, as a bridgehead, if you like, as the shoulders of these women, they're going to bear the brunt of the affordability difficulty. Well, we'll shove it down the line, and they'll have to bear it. Terribly sorry, but we'll give you plenty of notice. I mean, that's part of the argument. But we say, well, if you're going to be bringing in legislation of this kind, you certainly do need to give plenty of notice. And I would like to address the point that the Lordships raised yesterday, and we've sought to answer it overnight. I hope these documents have also got to you. There are two statements of both of the claimants, which are cited in part in the judgment, but I'll pause just to see. They should be, if there's been time to do it, behind tab 9 and 10 of the supplementary bundle.
I'm afraid that won't help, so we've only got the one. If we've got the tool, we'll only have an electronic signal, sorry. I will.
Oh, I'm sorry.
I can't speak for my lord.
Yes, I got them.
This is the statement of the two witness statements of the claimant. Yes, I got those this morning.
Sorry about those. I didn't have a chance to read them, but I have got them.
My Lord and my Lady, I don't intend to obviously read the whole of them. Some of the parts of it have already been cited. The one I was dealing with yesterday, who is the second applicant but earliest in time, doesn't, and the point I want to address to your Lordship is, what difference would it have made to these appellants, had they known 10 years in advance, 5 years in advance, in sufficient time. And we say simply, the answer to that is planning. And I'll develop that in one moment. One statement actually addresses it directly, the other doesn't. But in the statement of the applicant I was dealing with yesterday, the paragraph that's in the judgment is paragraph 8. But paragraph 9 that follows it, may I just read, it's very short.
I'm so sorry, which of the statements are we in?
Sorry.
Are you not naming them for a reason?
Well, it's not particularly, but that is the way it's been done throughout.
Which one you're talking about? Try, give them a
Carrington.
JD, you're Carrington, right? Okay.
This is the one today, and it's cited. Much of it is cited in the judgment, but not all of it. That I first became aware of the change is paragraph 8. That's in the judgment, but the next paragraph isn't as it stands. Being in such poor health, yet having to continue working 2 days per week and caring for my elderly parents on very little money has led to me being very depressed. In my darkest moments, I've thought, I cannot cope with much more. I feel lost. Well, there's more in the next paragraph, which is in the judgment. But I'm just indicating how desperate it is for a number of women. That's not uncommon. The other one, I'll use the name as we are at the stage, Julie Dell, who's the first applicant, but later in time, she has been asked about it, and it's succinctly summarised in paragraph 11 of her statement. I have thought about what I could have done differently if I had had all the information at an earlier time from the DWP. Earlier in the statement she says when she did have that. An accurate and timely pension forecast would have meant that I knew that I would not be able to retire. I would therefore not have taken voluntary exit in 2012, that's from a job that she had. I would not have taken my occupational pension until I was 60. So, that is a very common...
I'm so sorry, can I just be clear about this? So she made those, she took a voluntary exit in 2012.
Yeah.
By 2011, she had a letter from her pensions provider, which
Yes.
did,
What
very
did
frankly,
happen until 2016 is paragraph 6. I requested my pension forecast. It was only when I received the forecast in 2016 that
No, I'm so sorry. I think we're at cross purposes, Mr. Mansfield. You were referring. I was just looking at paragraph 8.
8.
7 and 8, in fact.
Yes.
Which is in connection with her deciding to cap in or to take early her occupational
It
pension.
is, yes.
And at that point she was told, as you say, and as she says, not by the government, but by them, that her pension would be payable when she reached the age of 65. Now I try to understand, she says she didn't read it or she didn't take it in and understand it. But I was just puzzled at the idea that anyone would be advised to cash in a pension early without having advice about their state pension position. And it looks as if she did, but again, I'm not getting at her in any way, but if she did in fact get such advice in connection with that particular choice she made.
I mean, I don't want to speculate unfairly, but I think it tends to be this, with this generation of women, because it had existed since 1940, not that they were born then, but they had lived with a case in which I think women could hardly believe that the state pension that they worked around wasn't going to happen.
Yes.
Even though there have been hints at it, conversations overheard and so on, until you actually see it written in tablets of stone in a brown envelope, saying, yes, this is what's going to happen, then you suddenly realise, or you do realise, that you have to do something about it. And my point generally would be this, that I think your lordships and your ladyship would entirely accord with this approach. Where, in life, I hope I'm speaking from the point of view of everyone. You do think occasionally, not often, about what it's going to be like at the other end, which I'm already in, of course. What is it going to be like? How am I going to be able to sustain myself? One, I might be single then, or I might be married, or I might have got a second marriage, all sorts of questions. But you need to be able to start the business of, especially within the decade prior to your expected retirement. Be thinking, well, now what? My pension's going to be so-and-so. And you tell your husband he's getting a pension if he's lucky. Or if there isn't a husband or a partner, you're on your own trying to work this out. Big questions arise then. Where am I going to live? Can I afford to live there? Can I afford to go on living where I am living? Can I afford to go on more holidays, or should I scrap that, stay at home, save money? Because a lot of people use up their savings. And so it goes on. The questions that have to be answered by the individual are enormous, including, obviously, staying in a job, keeping a pension, and even topping it up. So when you do retire from your occupation, you get more in that pension. So they're interlocking questions of fact for everyone. And I think no one would dispute any of that. And in that context, therefore, we say it was a reasonable expectation that they had that they would get it, and they reasonably tried to plan, and some are trapped. Some can't do anything much except prepare for the worst, because they haven't got the facilities, they haven't got the training or whatever. But even if they're not trapped and can do something, they need to be able to do something and prepare the pathway to a very different retirement than the ones they've got at the moment, which we say is besieged and beleaguered. And that is this cohort. Lord, I hope I've made our position as clear as I can in relation to notification.
That's very, very clear indeed. Thank you very much indeed, Mr. Mansfield. Looks as though we have no further questions for you. We're extremely grateful to all counsel for their presentation on this important case. We will, of course, consider all the arguments and we will consider our judgment or judgments. In due course, when they're handed down, will counsel please agree a form of order? Any further submissions should be in writing. We don't wish to have any further oral submissions unless we specifically ask for them. But we thank all those who have addressed us and those who have supported them in preparing and presenting this case. Thank you all very much.